Okay, hello again. It's Sunday, June 5th. This is the second of two videos on Unit 1. And in this 15-minute or so video, I'm going to be reviewing the North Carolina cases. And again, this is a kind of a set piece. It's a case study that illustrates some broader points about precedent, legal reasoning, how legal reasoning works, how arguments develop in a common law system based on precedent, and the idea of following precedents. So I'm on slides 17 and 18, and our key questions are what is legal reasoning, what is precedent, what is stare decisis. Stare decisis is a slightly different idea than precedent. Precedent cases are cases that are like cases decided in the past that are relevant. Stare decisis is the norm that, as a general matter, prior decisions in like cases are to be followed. Prior cases articulate rules and principles that govern how that conflict is decided, and in a similar case in the future, those principles and rules have the authority and status of law, and they are to be followed. So, in general, what is legal reasoning? Well, in class we said, and I'll repeat, legal reasoning is, for the most part, reasoning by analogy. Right? In a common law system, like England or places colonized by England, judges make law reasoning from case to case. So the idea here is precedents and decisions in prior cases are to be followed unless there's an overwhelmingly powerful reason to depart from precedent and overrule a prior case. And this immediately has a certain implication. It's kind of a conservative implication. In a common law country, law looks backwards. You have to orient yourself to the past, to what's been done in the past, to what's been decided in the past, and work within that framework of materials. And we said that this system protects values that don't necessarily depend on those prior cases being rightly decided or moral. Predictability, stability, uniformity, the idea of justice that says like cases should be decided alike. And all of these are constituent parts of a broader kind of notion, the aspiration that we're after, which is the rule of law, to be governed by rules as opposed to the discretion or whim of officials with power. That only makes sense if you conclude that the way that reasoning works in these cases and other cases in a precedent system confines the discretion of the decision maker in some sense. Can't eliminate it, but does it hem in and channel the discretion of the decision maker? So an oversimplified version of how this works is a case presents a set of facts. The judge decides which rules or principles apply by looking at prior like cases, and then makes a decision based on that, right? So you have to look to the facts of prior cases and the rules and norms in the prior cases, and then apply those rules and norms to the present case. But everything depends on similarities and differences. Is this case like that case? Is this case different in a significant way such that the rules or principles governing it should be different? So you have to pay attention to both the particular facts of a prior case, the norms and rules articulated in it, and the particular facts of the present controversy. And all of this is going to be controversial. Right? And even further complicating the picture is that in the real world, the facts are not uncontested. People have differences about what the facts are. Evidence is, contradictory. And interpretation is involved in making arguments about similarities and differences. So, there is an aspiration here to the rule of law, and the cases we have give us a way of thinking about how much discretion, how much indeterminacy, how much determination is there. you'll notice that if you think from the perspective of a litigant or a lawyer, you're trying to locate these rules and principles in some broader form of storytelling, in narratives, in rhetoric. Facts take on meaning in light of larger frames of reference, larger stories, right? So we have 6 cases from North Carolina, bracketed by some comments by Carl Llewellyn, a famous law professor from the last century. We'll get back to Llewellyn later, but now let's just start by going through these cases one by one, and we'll see how this works. One scholar called legal reasoning from precedent in prior cases, a moving classification system. The categories and concepts and classifications are actually reinterpreted as they're used and applied. And each key term can take on slightly different meaning in relation to redefinitions or reconceptualizations of all the other terms. We have a number of terms in these cases: intent and malicious intent, provocation, the domestic curtain, lots of ideas that are moving together, and we want to see how this plays out. The first case is, so you can turn to, on the PowerPoint I go through the how to brief a case, how to highlight the facts, talk about the procedural history, state the issue in the form of a question, state the holding or result in the case, who wins, what's the answer to the question, and then most importantly, a summary of the reasoning in the case. How does a judge justify a decision as required by law by going from A to B to C to D? What's the logic? If you can see the moves, then you can examine the moves, and we'll illustrate that as we go through these cases. So I'm up to slide 29, and here we have State v. Pendergrass, and this is a case in which a teacher, a school teacher, is prosecuted for beating a student. And we see in this case the starting point. What's the first move? The opening move the court makes in thinking about the authority of a teacher to use physical force against the student for purposes of discipline is an analogy. This happens often in law, that one relationship is like another, and we should think about it the same way. So the parent-child relationship is the primary relationship of upbringing, socialization, education, if you will. And the teacher-student relationship is much like the parent-child relationship and should be thought about in the same way. So that's a move. Does that make sense? Certainly makes sense in this society. This seems to be a society where people can't imagine relating to children without using physical force. It's allowed, but what are the limits? In this case, we're told that the beating was pretty severe. There were bruises on the child. We're not told much about the individuals, what exactly happened, what the child did, and I don't think that's accidental. The point of view taken is the point of view of the teacher and authority and the need to maintain authority. The teacher is convicted at trial. The trial judge tells the jury, there's a division of labor. The jurors don't know the law, they have to be told the law. The trial judge told the jury that teachers do have this power to use physical punishment, but if the jury found that the injuries were the result of this beating by the teacher, they should find her guilty. And I guess his thinking was something about the extremity of the punishment or the disproportionality of the response to whatever the infraction was. And we're not told in the opinion what the infraction was. And the teacher appeals that conviction. Now, the court on appeal, in the opinion we're reading, overturns that conviction and holds that the teacher did not exceed her legal authority. And it says there are 2 limits, and we saw that there's a starting point for stating those limits. The reason we let grown-ups hit children is for their own good. The welfare of the child is the purpose. That idea leads to a first limitation, or the first prong of a 2-prong test. The first limit is you can hit the child, but you can't cause permanent physical injury. If you cause permanent injury, you've exceeded your authority because that's not consistent with the long-term welfare of the child. That makes a certain amount of sense. We might confront questions of what is or is not permanent injury. That's a possibility in the future. Everyone agrees there's no permanent injury in this case. As it turns out, in the subsequent cases, we never face that question of what is or is not permanent injury. All right, so we don't have to worry about it here. We might, we could. But there's a second limit, and this one is different. First limit has to do with the impact on the victim. The second limit has to do with the what's going on in the mind of the perpetrator, of the punisher, the teacher in this case. What are her motives? What are her intentions? And this is expressed in the idea that the intention of the punishment, even if it doesn't cause permanent injury, can't be malicious. The way the court puts this is the teacher can't be acting to gratify his or her own bad passions. So there's an idea of good faith. You might make a mistake, you might get out of hand a little bit, but if you're in good faith and you're not just acting on the enjoyment of inflicting punishment on someone else, then you haven't crossed the line. This is terribly vague. What is this going to mean? Even if you don't cause permanent injury, if you're acting with malicious intent, you've crossed the legal line. Well, we know that the court concludes in this case that the teacher did not act with malicious intent. She may have inflicted severe punishment, but she was in good faith. She was trying to do her job. So you can make mistakes, and you can maybe be a little excessive if your motives are good, as opposed to being malicious. So we have this two-pronged test governing the authority of a teacher. Now that analogy from parent to child to teacher to student is going to make its way into the relationship between husband and wife, and we're going to be thinking about all of those relationships in similar terms, which is interesting in itself. The distance between us and these cases, it magnifies some of what we regard as the absurdities, right? We can see that move very clearly as questionable. Women are not children, but they were legally, in many ways, regarded as inferior beings who needed to be dominated and disciplined by their husbands in a marriage. Okay, now the bridge from the teacher-student relationship to the husband and wife relationship comes in a case called Joyner v. Joyner. This is the only one of the 6 cases that is not a criminal case. You'll notice that all of the 5 other cases are State v. Pendergrass, State v. Black, State v. Rhodes. This one is Joyner, Ms. Joyner versus Mr. Joyner. It's a civil case. It's a case for divorce. No one's going to jail. The married woman wants a divorce, and her allegation is her husband hits her with a switch and hits her with a horsewhip and is verbally abusive, and she wants out of the marriage. And the trial judge gives her alimony while the case is pending, and the husband appeals. And when he appeals, apparently he's saying, I haven't been given sufficient detail about the allegations against me to defend the case. And she has to be very specific, because divorce is unusual, and you can't get it very easily. She has to be very specific about what happened. Did she say what time and place these actions allegedly took place? No. The court says we don't care about that. I mean, she could show the time and place at trial. But, big but, right, big, however, she did not state the negative proposition that she did nothing to bring on the beating. That is, if she was out of line or provocative, if she provoked the husband and needed to be disciplined, it could be the case that he could hit her with these weapons and be okay and be completely justified. And if he did it, just for the hell of it, maybe not. But she didn't say one way or the other whether she provoked him or not. And this introduces the idea of provocation into the picture. Right? And that's going to be a very important idea throughout these cases. But in any event, her lawsuit is not sufficient, and there's a lot of rhetoric in here. The court quotes the book of Genesis, the wife has to be subject to the husband, and he may hit her if she isn't behaving herself. So you get the idea, without any factual basis of whether she provoked him or not, or what provocation might mean, but you get the idea of provocation. So you want to keep your eye on that idea of provocation and what it's going to mean in relation to the second prong of the test, which is, was there malicious intent or not? Those two things could be related in different ways. All right, so the next case, and this is the first case of a prosecution of a husband for hitting the wife, is State v. Black. And in Black, the court applies the reasoning from Pendergrass and Joyner to apply this two-pronged test. This is a criminal prosecution for the husband. We're not told much about the altercation. We're told that the parties are still married but living separately. We're told that the wife was verbally abusive toward the husband. We're told that he pulled her to the ground and perhaps pulled her hair, but he didn't choke her, he didn't punch her, and after he let her get up, she continued to be verbally abusive. This is what we're told. We're not really sure what all that means, right? How violent it was, we can't really tell. But here the court embraces this two-pronged test. What are the limits on the husband's authority to use physical force? One, he can't cause permanent injury. And two, he can't be acting with malicious intent. And in Black, the court introduces a somewhat new and broader idea. We haven't seen this imagery before. It's the idea of the curtain, right? The curtain shielding the domestic form. And it is a very poignant idea. Like, you're not really supposed to lift up a curtain and look behind it because, you know, that's private. So we have the public and private split here, and the reticence, the reluctance to intervene in the domestic forum. Given the facts of this case, in State v. Black, the court says the trial judge, nobody's disagreeing that these are the facts, the trial judge should have told the jury, you must acquit, because on no understanding of these facts has the husband exceeded his legal authority. He was within his authority to do what he did to make her behave herself. No permanent injury, no malicious intent. We're not explicitly told the legal status of the idea of provocation. We're only told that the factual conclusion is the wife provoked the quarrel. All right, so that starts the process of legal reasoning in motion. We have the question of how far the authority of husbands to hit wives extends. No permanent injury, no malicious intent. The next case is the key sort of transitional case in the line of cases. State v. Rhodes is 4 years later in 1868, and you might ask yourself, well, why would a prosecutor think that this might be an easy case? We are told, and it's assumed as a fact, that the husband hit the wife, this time with a weapon. In Black, it was with his hands. In State v. Rhodes, he's hitting her with a whip or a switch, 3 blows. We're not told much about the violence at all. We are told that if he did this to a stranger, he'd be guilty of a crime, but it's his wife. But most importantly, we're told that there was no provocation, that she didn't do anything immediately around the beating to provoke the beating or warrant it. So we're going to assume no provocation. Now, if you're prosecuting the case, what you're going to say is, well, if this beating was unprovoked, it was by definition malicious, and if it's malicious, he's exceeded his legal authority and he's guilty of an assault on his wife, and he should be punished for it. That's not the answer the court gives. The opinion in State v. Rhodes betrays a lot of anxiety. The court begins by saying, you know, this is a tough case. The question presented is whether chastising without provocation is inherently malicious. And it starts out by saying, we know we're kind of, our law is not the law that most other states or countries have. It's us in Mississippi that have these kinds of rules that give the husband this much authority. So we need to say why we're deciding that the husband has not exceeded his legal authority when you otherwise might think he had. And here the two-pronged test is recast again in a still broader framework compared to the domestic form, but something called family government. And I think the big sort of narrative here is that intervention into disputes is likely to do more harm than good. The adversarial process widens the breach, makes it much less likely that people are going to forgive and forget. This kind of thing doesn't belong in court. So what we've been meaning to say is not if he abuses his authority, but if he grossly abuses his authority. And if it's a trivial kind of thing, if it's a minor thing, we really should stay out. And we do that in order to promote domestic harmony. And we're all better off in the long run if we don't open the courthouse doors to these kinds of trivial complaints. So the husband's going to be found not guilty. The husband in this case, and this is a wrinkle, you could pay attention to it or not. It's not essential, but it is confusing. At trial in Rhodes, the husband was found not guilty because the size of the weapon he used was small. So the trial judge was sort of out to lunch on what the law was. He got the law wrong, and they decided the case based on the size of the weapon, which was folklore, not law. On appeal, the husband still wins, but he wins because we're not going to say that this rises to the level of malicious intent. State v. Black is the law, but this is not malicious intent. It's important to sort of bend over backwards not to hear trivial complaints. And at the end of the opinion, I think something sort of terribly important happens. There's a lot of anxiety in the opinion. I don't think the judges are very comfortable with what they're doing. They're signing off on this unprovoked beating is what they're doing. So they want to say, we're not saying it's right. We're not saying it's morally good. The husband does not have a right to do this to her. But for motives of public policy with respect to the consequences of intervention, it's like a cost-benefit analysis, we'll stay out, and we're going to define this one as trivial, as below the level of grossly abusing authority. And in class on Thursday, we talked about, I want you to look at and pay attention to the note question after State v. Rhodes on page 14, question 2. Your editors want to say, you know, this is ideology. They are giving the husband the right. They say he has no right, but because they're letting him do it, he in effect has a right. It might even be worse because you're lying. You're covering up the fact that you're saying it's right. And that's a plausible interpretation, right? That if you're kind of hiding the fact that you are letting the husband do this sort of thing. The court on the face of it says he has no right. We don't say that two 14-year-old boys have a right to hit each other on the playground, but we don't drag them into court, I guess is what they seem to be saying. And my sort of different interpretation of that is that may be true, that it is in effect giving him the right, if giving him the right is giving him the factual power to hit her like this. But I think it could matter in the future that they say there's no right, because then that shapes the future conversation. So what we're trying to get at here is the way legal doctrine channels your thought and your argument in certain directions and not others, without tightly determining answers in the future. But to me, if you've said he has no right, but it's just a question of what does more harm than good, then in the future we're going to be talking about what does more harm than good. You may be able to say that intervention does more good than harm in the future. In any event, it's important to me for the law to say there's no right, even if Rhodes is allowed to do what he did. Okay, so the next case, 2 years later, State v. Mabry. So in Black there's no weapon, in Rhodes there's a switch. In Black there's something called provocation. In Rhodes there's no provocation, but the husband is still within his authority. He hasn't acted maliciously according to the North Carolina Supreme Court. In Marbury, we have a husband chasing a wife with a knife and swinging it at her, and he swings and he misses, and he swings again, and a bystander catches his hand, and he's tried. And at trial, the jury finds the facts, and the trial judge looks at a snippet of the opinion in Rhodes. You'll find it at the end of the opinion in Rhodes on page 14, where the appellate court says, you know, we don't understand why you used the size of the weapon in Rhodes to find him not guilty. The standard is the effect produced. Well, in Marbury, the trial judge looks at Rhodes and says, well, if the standard is the effect produced, this guy didn't produce any effect because he didn't hit her. Therefore, he's not guilty. On appeal in Marbury, in an opinion by the same judge who wrote Rhodes, the husband is found guilty. And the argument for finding him guilty is pretty obvious. If attempted murder isn't malicious intent, then what is, right? We're still following the law of Black. You can't cause permanent injury, you can't have malicious intent. But these facts are outrageous. He's trying to kill her, he's threatening to kill her. That's malice, he's guilty. So this is the first time the husband loses, and it's a pretty extreme case. We're not told anything about provocation or what brought on an attempted murder, but here's the first time the husband is found guilty. Okay, the final case, slide 33, is State v. Oliver. And here we're given a little bit more detail about the assault. Husband comes home, somewhat intoxicated in the middle of the night, doesn't like his breakfast, angry, starts throwing things around. He goes out, he cuts 2 switches, 2 tree branches, holds them both like baseball bats, and he hits her all his might 4 or 5 times. We're given more detail here, right? And there are bystanders, and they urge him to stop, they tell him to stop. He says if he hadn't been stopped by the onlookers, he would have worn her out, which is a euphemism for hitting her until she's dead. And there isn't any discussion of whether she did anything to bring on this beating or caused it. So the idea of her provoking it is not here. And you can, the opinion is very short, and it just, all that we can say based on the opinion is this is malicious intent, right? And you want to read it carefully, right? The courts have advanced from the barbarism of the rule of thumb. We have held that the husband has no right to chastise his wife. What does that mean? That's what they said in Rhodes, and the husband got off, right? The husband has no right to chastise his wife under any circumstances, but from motives of public policy and in order to preserve the sanctity of the domestic circle, the courts will not listen to trivial complaints. Right? Better to shut out the gaze if there's no permanent injury and no malice. No general rule can be applied. Every case has to be judged on its own. And then the conclusion, this is malicious intent. So this is not allowed. So this violates the second prong, and the husband loses. There's a rhetorical statement at the end about how it's difficult to conceive that any man could hit his spouse, his wife, without having malice and cruelty in his heart. It's difficult to conceive it. Is it impossible? Where are we? What do we know? What don't we know? So I'm coming up on 30 minutes here. I'm going to wrap up. What I would urge you to do, though, is ask yourself, after Oliver, how would a case like State v. Black be decided if the exact same facts occurred and were decided after Oliver? So how would State v. Black turn out after Oliver? Has the law changed such that Mr. Black would be guilty of assault? And I don't think we can answer that question. The tendency is toward more limitation on the husband's authority. There's no provocation in Marbury or Oliver, right? So we don't know what the relationship between the idea of provocation, the gendered idea of provocation, only women can provoke the beating, right? And and malice is going to be. How would a case just like Rhodes turn out after Oliver? Well, it seems to me that Rhodes and Oliver are similar on the facts. They're both beatings with the switch that were unprovoked. Was one more severe than the other? It's really hard to tell. You might say that Rhodes might come out differently because it's very similar to Oliver. But the hanging issue is the question of provocation and the relationship between provocation and malice. Okay, so there's a hypothetical case that's on Blackboard that poses this issue, this next case. And I'm going to ask you on the discussion board to, give a response to this hypothetical case. What do you think the arguments on each side would be? How would you predict it would come out under the law? If these 6 cases are the law, how does this 7th case get decided? And then on the final slides, right, there are slides 35 and 36. We want to step out now. I'm going to do this in a minute, 1 minute. I've been talking for 30 minutes within a language, a set of terms that are given and must be talked about to talk about how the courts are deciding these cases. What haven't we been talking about? What else might be going on in the society that the legal conversation kind of diverts us from? You see how you get sucked into this world and you can't help but speak its language. You can forget that this is a society that's gone through unbelievable changes. Slavery ends, there's a civil war, there's Reconstruction, there's the end of Reconstruction. There are lots of relations of domination and subordination in the society, aside from gender and domination. Have we lost track of fundamental questions of justice? Are there other ways of framing and looking at these problems? Law narrows. Law narrows the conversation and forces us to talk in certain terms. Even if we're going to fight about what these concepts and categories mean, what I think is going on here is the idea of malicious intent is stated in black and it's kept, but its meaning evolves a bit to encompass more violent content, more violent conduct and content. So what malicious intent means seems to be evolving a bit, but we can't say exactly how far. More broadly still, I would urge you to look at the final slide, slide 36. And here, what is going on here? What are the virtues and defects of this way of proceeding, stepping back from the particulars of the cases? In class, we mentioned that one good thing that might be said about precedent is that if change comes, it should come slowly. This is a way for society and its laws to negotiate stability and change, to have change but not have it be too drastic. To allow cultural norms and values to kind of seep into the terms that are given. How much predictability, how much rule-bound order are we getting? How much discretion? Another broader question is, what's the relationship between the legal doctrines and what's actually going on in households and in society? And these materials don't allow us to say anything at all about that. Right? The law might be looking better and better, but the reality might be the same or even worse. We don't know, right? If you're paying attention, you realize that these cases get into court mainly because there are witnesses and they happen in public. They don't happen behind closed doors, right? So we can't say much of anything about the relationship between law and society just by reading these materials. What kind of artifacts they might be would require further inquiry, right? The last slide asks you to consider 2 definitions of precedent. One is from a famous legal philosopher named H.L.A. Hart. And it says, precedent is a means of controlling an indeterminate present. We're not sure what to do in the present, by reference to an already determined and therefore determining past. So this is the kind of optimistic view that we're looking to the past for guidance, and that past does provide guidance. Maybe not ironclad rules, but certainly guidance. The second definition is by someone who's a little more cynical about all this. His name is Stanley Fish. Precedent is the process by which the past gets produced by the present so that it can then be cited as the producer of the present. In other words, the past here is sort of a fiction. It's constructed in the moment so that it can be invoked to justify as law what I have the power to do now. And that's a more skeptical view. Which one makes sense? Whether it's something in between, I'll leave to you. We'll leave Carl Llewellyn for another day because I'm already over 35 minutes. And so with this video we conclude Unit 1. I'll put some stuff on the discussion board about it. And tomorrow, Monday, we move on to Unit 2, and I'm going to stick to it. It's the adversarial system, legal education, adversary ethics, and we meet a few lawyers and clients in that material, and I will produce a couple videos about that for tomorrow. Okay, thank you.